One of the things that you see with clients is when they get sued, there's that initial instinct of, gosh darn it, and you read through the complaint and you see all these things that are just wrong and you get really fired up and angry. The natural reaction then is hire my lawyer, file that motion to dismiss, get this case dismissed because it's all wrong. The problem that you face with that is oftentimes there is something at least truthful enough to survive a motion to dismiss. And what you do, though, is if you make that sort of wholesale motion to dismiss, you spend a lot of time and a lot of money, and you don't win. A better course of action, and many, many times, is step back, take a breath, counsel your client to do the same thing, and evaluate the claims. Realistically, what can we win on a motion to dismiss? What should we leave for summary judgment at a later time? What should we develop in discovery? The consequence in that is when you are done winning where you can win, the case is narrowed substantially, the landscape has changed. Now suddenly the plaintiff isn't so high on itself, and now you have more of the momentum. A lot of the dollar figures that they assert in their claims don't exist any longer, and you can evaluate going forward where to spend your money better. To convince a client to go with a two-pronged approach is difficult at the outset, and it takes a little level of skill and diplomacy because the client really wants a litigator to be an alligator. Get in there and tear everything up, right? I got sued and I want you to beat that guy. So you have to be diplomatic and more tactful in saying, we will be there, we'll get there, but the better approach right now for you and your business is win where we can. We'll take that, and then if we can narrow the case really substantially, we can engage in settlement discussions, get this case settled and resolved very quickly and very cheaply, and I'm telling you, Mr. Client, that's better for your business. No, it does not pertain to all cases. In fact, you really do have to evaluate the complaint itself. If the complaint has a lot of merit, then you can't make your motion to dismiss. If the whole complaint is bunk, then you do make the motion to dismiss. And you have to be flexible and be able to evaluate what's said in conjunction with your discussions with your client. In my experience, courts actually prefer lawyers who act reasonably and address the problems in a complaint reasonably. They do not like to be deluged with tons of paper, much of which is not necessary for the task at hand. They in fact will look at the lawyer who prepared the motion and say, thank you. Now I can address what you've put in front of me. I can understand better that this complaint has these flaws in it. And yes, it won't get rid of the entire complaint, but from my standpoint, it's a lot less. And then what the court does next is say to the plaintiff, you might want to resolve this. Now that I've dismissed 75% of the complaint, it is in your interest to have a conversation with counsel and resolve it outside of the court any further. You will do better if you take a sound, reasoned approach to litigating that includes not necessarily winning everything at once.